members of Congress are subpoenaed on behalf of defendants in prison, people that have gripes against the government, and the president receives far more than one a day. Would you suggest that he should have to go to those places, show up and be deposed just because somebody wants to depose the president and says they have a basis?
Obviously, there's a general policy reason not to.
Okay, so the fact is that the Supreme Court's decision on limited immunity or immunity from prosecution, immunity from having to show up and be distracted from the work of the president is for a good purpose, and only in rare cases, such as Bill Clinton's case of a civil suit specifically about actions before he was president, has the court ever said it doesn't fit there, right?
I think that's exactly the problem you point out, is it's so rare that there is no need for them to.
Well, let's just get back to rare. There was need. They made a decision that still stands today, that Bill Clinton could be deposed as to his specific state actions prior to being president, but they ruled clearly that the president cannot be distracted from that. I'm going to switch to Mr. Smith. I'm going to let him drink his water. You know, you said as a prosecutor, I'll go to you and to Mr. Judge Wilson, that this was not a fair trial, that it violated the rules that we count on for the admission of evidence. Is that correct? You both saw that in this case?
Yeah, if I may go first. I think the most glaring thing was some of the Stormy Daniels testimony, which, you know, the implication from her testimony was that she was sexually assaulted by President Trump, which is, you know, in any respects, so unfairly prejudicial relative to the crime.
The judge clearly let evidence in.
And that was surprising to me, one, that the prosecutors didn't know that ahead of time, that this was going to come out, and it wasn't vetted ahead of time. So that's the most glaring example that I
So as a prosecutor, something that you dedicated your career to, there is a sense of balance. If you get in your unfair twisting, you normally expect the judge to, at least at a minimum, allow the defendant to present witnesses in response to that, or to offset. It was pretty unheard of that they only let you hit the guy and no one answer back.
Right, that part of it's concerning, and when you think about it, when we would prosecute cases, generally defendants had far more leeway, because it was like they're the ones, they're in jeopardy, they're, you know, going to jail or whatever. So even if they didn't have necessarily the most viable defense, it was rare to have a judge cut them off on it. And that's what just seems so striking. On one hand, it's the most extreme evidence allowed against President Trump, which is hard to justify, and then not allowing some sort of at least explanatory evidence.
And then, as my time's running out, but yes or no, if I could, isn't that kind of imbalance very often exactly what a prosecutor doesn't want to see, because it leads to a high probability of a case being reversed based on not being fair? In other words, if you deny the defendant, you have a jeopardy of in fact getting a perfectly good conviction overturned because you didn't give them the proper opportunity for defense, didn't give them the charges in advance, didn't give them the evidence that you held. Is that right?
Yes, and it goes to question the motivation for this case. Was it just to get the initial conviction?
And now let's go to the motivation with Mr. Smith. You were denied the ability to answer a great many questions, so hopefully you'll be able to answer the ones you want to here today. Have you, in your history with the FEC, have you ever seen the FEC take state charges and link them to an FEC violation in order to get a felony and then take it to the federal court and charge somebody?
No.
So the federal government doesn't grab state cases to make something that is normally a fine and make it a crime, correct?
No, it does not.
Okay, and so if you had a situation in which, and this is an if because it didn't happen, but if you had a situation in which somebody took their own money and used it and then did not declare it, is that usually, you know, there was failure to file, is that usually something that you would bring them up at the FEC and refer them for criminal felony charges?
It would be extremely rare that it would be referred for criminal charges. You'd have to show clear intent.
So in this case, specifically, the FEC made a decision that what they pulled in addition to state to make this a crime that they could charge a felony on is something that not only normally wouldn't happen, but in this case specifically was looked at and didn't happen. The FEC declined to prosecute because there wasn't a case here, right?
They not only declined to refer it to justice for criminal charges, but they declined to bring civil charges themselves, which is what you'd normally do if you just thought it was an error or something.
So it wasn't even worth a fine, much less a criminal prosecution.
Right.
Thank you. I yield back.
Gentleman yields back. Gentlelady from Florida is recognized.
Thank you, Mr. Chairman. When Donald Trump's Supreme Court overturned Roe v. Wade, millions of Americans lost the right to make their own health care decisions.